My name is David Haig, and I was tased 10 times on December 18th for trying to present evidence proving my case, and that evidence would also prove serious criminal conduct by government officials and private defense attorneys. Since I wasn't allowed to present my evidence in court, I'll try to do so here. On December 21st, 2016, the Court of Appeals, in their Memorandum Opinion, limited me to evidence that would make it almost impossible to win my case, and they did so by falsifying the way they eliminated the evidence. In their order, the Court of Appeals states Haig's claims of prosecutorial misconduct and statewide corruption. Haig alleges he's a victim of a wide-ranging conspiracy intended to frame him in order to protect the infant wolf control program from program-ending scandal. To this end, Haig claims that the state attorneys responsible for prosecuting his case, Haig's own attorneys, and that's what I'm going to be talking about in this evidence packet, the Alaska Commission on Judicial Conduct, the Alaska Bar Association, the Alaska Public Defender Agency, and virtually every judge involved in his case have all colluded, and remember that word, together in a vast conspiracy against him. Haig's allegations are, for the most part, simply unsubstantiated general allegations of wrongdoing without any specificity or support in the record. We therefore agree with the District Court's decision to dismiss these claims for failure to state a prima facie case for relief. As we explained in LeBrake v. State, courts are not required to simply, quote, assume the truth of pro forma assertions of the ultimate facts to be proved when these are not supported by specific details. And what I'm going to do is show the briefing that was given to the Court of Appeals before they made this opinion in 2016. Here are the briefs that I gave to the Alaska Court of Appeals on July 24th, 2013, and then the reply brief, January 15, 2014. I'm going to read the details that I gave to them. Haig fired attorney Chuck Robinson, couldn't find an outside attorney to go after attorneys Robinson and Brent Cole, and hired Alaskan attorney Mark Osterman. Haig recorded every conversation with Osterman, from hire to fire. After looking at the evidence for a week, Osterman stated, quote, it was a disaster in it. What Chuck Robinson did was wrong. What Cole did was wrong. Robinson should have went after Cole. It's the biggest sellout of a client I've ever seen. When the Court of Appeals sees the sellout, they will overturn your conviction. It was ineffective assistance of counsel. Prosecutor Scott Leader stomped on your head with boots. He violated all the rules, and your attorney allowed him at that time to commit all these violations. I can't figure out why Chuck's protecting him, Cole, and we will sue for millions. Osterman stated everything should have been protested. And, quote, you didn't realize Robinson Cole was going to set it up so the states, dang dice was always loaded. They, the state, were always going to win. Osterman stated the bar protected crooked attorneys. In 2006, without knowing, days later the FBI would raid 10% of Alaska's legislature for corruption. Attorney Dale DeLifka, Zellers, Wendell Jones, a former trooper whose testimony Greenstein falsified, Greg Kaplan, then Congressman Don Young's deputy director, and Haig met with Department of Justice Section Chief Colton Seal to testify of the foregoing corruption. Seal stated that Department of Justice had multiple complaints that defense attorneys in Alaska were conspiring with prosecution and judges to rig trials against their own clients, with every investigation, quote, expanding rapidly and implicating nearly everyone involved, unquote. Attorney Brent Cole was deposed and refused to answer incriminating questions after Assistant Attorney General Andrew Peterson told him not to answer them. Cole testified that he had testified truthfully about Haig's case in the past. Cole previously testified the state gave Haig immunity, and Alaska Statute 12.50.101 and State v. Gonzalez hold you cannot be prosecuted after being given immunity. The state harmed and threatened to harm Haig's attorneys if they tried to defend Haig. United States versus Chronic, U.S. Supreme Court, 1984. Haig's attorneys had interests in conflict with Haig's, and this affected how they represented Haig. The state's threats and resulting conflicts explain perfectly all puzzling inaction by Cole, Robinson, Osterman, and even DeLifka. Haig's attorneys never protested the state's use of known false evidence and testimony against Haig, effectively never protested the use of Haig's statement against Haig, never protested the use of Haig's map at trial, and affirmatively gave Haig false advice of rights after Haig specifically asked about them. Haig's attorneys then committed perjury during their depositions to cover this up. And the state case Smith, I think, versus state, highlights how that's wrong. Attorney Chuck Robinson is recorded stating, "The good old boys of judges, attorneys, and troopers in Alaska protect each other when they commit crimes. Things only unraveled after investigation, forcing attorneys Cole and attorney Fitzgerald to testify under oath. The state gave Haig immunity for his statement, and afterward prosecutor leaders stated he was not going to honor it. Immunity in Alaska means there can be no prosecution. Big problem. When prosecution cost Haig, his wife, and daughters everything. Sellouts result. If Haig's attorneys had protested the state's involvement and false evidence and warrants on day one, prosecution would have ended on day one. Haig would have paid his attorneys about $1,500. But by letting the state illegally build a devastating case, they forced Haig into paying them hundreds of thousands, increasing their take 100-fold. The state got to corruptly protect the wolf control program, got hundreds of thousands from Haig in fines and forfeitures, and will get a lodge and improvements Haig built on leased state land for a guide career that's gone. The good old boys win big, unbelievably big, unimaginatively lucrative carrot for attorneys to play ball, overpowering when combined with the stick of state retaliation if they defend their clients. Unfortunately for the good old boys, Haig put the pieces together in time, presented it to the sleeping giant, what attorney DeLifka calls the unaware public, and the public woke up. I declare under penalty of perjury the foregoing is true and correct. Executed on July 8, 2013. David Haig. Now I'll go to the reply brief. Attorney Brent Cole testified his tactic for Haig's defense was for Haig, quote, to fall on his sword, unquote, but refused to answer if Haig agreed to this tactic. Falling on your sword is suicide. No attorney would use his own client's suicide as a defense for his client, especially if the client never agreed to it. And what Cole meant by suicide is he meant that he let the state falsify evidence and destroy evidence to convict me. Attorney Robinson himself wanted to stand mute at Haig's trial, claiming no other defenses could be brought up as this would admit court had subject matter jurisdiction. Only after Haig demanded did Robinson speak, but never brought up anything such as the state told Haig it was in the public's best interest to take wolves anywhere but claimed they were taken in the program. 2, never brought up the state falsified evidence to Haig's guide area and knowingly presented this at trial and to seize evidence in airplane. 3, never brought up the state was using Haig's statement against Haig at trial in violation of Haig's rights. 4, never protested Judge Murphy was, quote, to quote Robinson, a law enforcement type judge and not the independent judicial type you're supposed to have, unquote. Robinson testified Haig's only trial defense was the court did not have subject matter jurisdiction because charging information wasn't sworn to. And then later testified he knew before Haig's trial that the state fixed this error prior to trial, meaning Robinson committed perjury and then lied to Haig that subject matter jurisdiction was a valid trial defense and appeal point. What better way to get your client convicted than to tell him you must stand mute for what you know is an invalid defense, and that for this invalid defense to work, you can't oppose false evidence presented against you. Deception of this magnitude could not happen without Haig's attorneys helping, thus the state's threats to them. Once they were helping the state convict Haig, why stop with covering up what the state told Haig and falsifying evidence to Haig's guide area? Why not give Haig immunity, force him to give a statement, prosecute him anyway, and use the statement to boot? Why not promise minor charges so he gives up guiding and then change the charges after he is broke? Why not illegally keep the plane he needs to provide a livelihood without the required prompt post-seizure hearing so Hig goes broke faster and maybe commits suicide? This is the sworn testimony from 35-year attorney Dale Delifka to Superior Court Judge Stephanie Joannides with Assistant Attorney General Andrew Peterson cross-examining. And it's an August 25th, 2010 representation hearing that happened after the hearing to disqualify Judge Murphy was canceled. And Judge Joannides canceled it because she ruled Judge Murphy must be disqualified even without an evidentiary hearing. Mr. Delifka, and the case that you had is very different than the normal criminal case because I knew, as did Mr. Obendorf, Hig's tax accountant, when you lost your airplane that your livelihood was impacted. Your life, because your livelihood had changed, is really what concerned me as your business attorney. Again, I'm not a criminal lawyer, but when things crashed with Mr. Robinson, I became more proactive in actually reading documents, and that's when I became very confused about your case. Again, not being a criminal lawyer, I still am an attorney, and I was very confused, even to the point of contacting Judge Hanson, my old friend from Kenai, a 20-year Superior Court judge, and I called him more than once about your case because I couldn't get my arms around it. It made no sense what had happened. And I don't know how you possibly had due process with regard to the seizure of your airplane. I have read it and read it and read it. I could write a doctor's brief on it. And I can't. I'm just wore out trying to figure it out because I can't. I asked him, is Mark, from what you know of the pleadings and stuff, Mark Osterman, my third attorney, is what happened with him what you feared may happen if I hired an attorney inside the state for a third time? Mr. Delifka, well, yeah, if you read the tape recordings he made of what he said to you, I mean, that part of when I said the hackles came up on the back, on my neck. How could a lawyer, especially who believes in ethics, read those tapes of things he said to you, assuming they were transcribed correctly, and not be appalled by what had happened? Okay, I say, okay, and do the recordings basically say, before I hire him, my God, it's the biggest sellout of a client I've ever seen by not only one, but two attorneys. And we're going to get this thing reversed and we're going to sue them. And then I hire Mr. Osterman, and then he flops around 180 degrees and says, not only have I spent all that money, which was supposed to be all the money for the appeal, but here's another bill for another $36,000. And by the way, I can't do anything for what I agreed was a sellout, quote, because I can't affect the livelihoods of your first two attorneys. Is that what appalled you in the transcript? Mr. Delifka, not only is that what appalled me, that is primarily what I sought counsel from Judge Hanson. That those were the things that disturbed me, Judge Hanson and I were talking about, as was Mr. Ingleson, about other cases that were just disturbing. And actually that's supposed to be Fred Angleton. But the main thing with yours that I would talk with Judge Hanson was, and I would actually call him and say, Judge, am I losing my mind? Am I reading this correctly? And he took an interest in your case, and I think he was shocked by those tapes as well, of what you just read. Your case became more and more troubling to me because it was endemic of our whole community. It might have been cutting edge, but it wasn't the only one. And for what Mr. Osterman said to you on tape should disturb any lawyer who believes in ethics of any kind. I asked him, okay, and I guess you answered this, but in essence, the fear or reason why you advised me to go outside the state was proven correct. It wasn't just a theory that this was going on. It was proven correct because of Mark Osterman, because the tape recordings, if you looked at them, I taped everything from the day I called him to hire him to the day I fired him. And so would it be fair to say that you and I, knowing this may happen, prepared, or I prepared for it, and Mr. Osterman proved that this is going on, that attorneys are intentionally not representing their clients? Assistant Attorney General Andrew Peterson jumps in. Your Honor, I just want to object. The testimony regarding collusion and corruption, I think, is better saved for the PCR hearing that's going to go, at least with respect to his first two lawyers, it's going to go directly to the issue of his PCR claim. And remember, in their order, the state said I never gave any details or evidence of collusion, have all colluded together. Yet here's an assistant attorney general admitting that I was presenting evidence of collusion. Judge Joanides jumps in and says, do you have the tape of Mr. Osterman's comments to you that he wouldn't take the case because it would affect? I jump in and say he wouldn't use the arguments. He took the case. Judge Joanides, no. But that he wouldn't use the arguments because he didn't want to impact their livelihood. You have that on tape? And I go, yes. Mr. Delifka, what I never understood and still don't, nor do other lawyers on your plea agreement, is how you believed you were going to plead to these lesser charges that was in place in theory. And the next thing we know, you go sing like a bird, tell everything you know, and all of a sudden the charges against you are just exponentially increased. What lawyer would have you lay all that out and get your charges increased exponentially? I ask him, do you remember saying that never has there been a case in history that cries out more for outside intervention because you've been all to the major players? Mr. Delifka, oh, I'm sure I said that, and I believe that. I ask him, do you remember saying something, sold your soul for a deal, and then the state and coal sold you down the river? Mr. Delifka, I could very well have said that. Okay, Mr. Delifka, because your whole plea thing just boggles my mind to this day. Mr. Haig, okay, other than an outright payoff of a judge or jury, it is hard to imagine anyone being sold down the river more. Mr. Delifka, I don't remember saying that, but I might have. Mr. Delifka, that could have been in the context of all this, the little travels. I mean, your stuff, even with the proprieties that went on, I'm so glad you got a new judge on this, and that was Judge Joanides, because one of the things that smelled so bad to lay people was all the stuff that you filed for a new judge about. The judge riding around with the trooper and commandeering vehicles. I mean, that smelled to high heaven, especially to non-lawyers. That was one of the things the community was most outraged was just, and I jump in and I say, well, and not only that, that when I went to the single investigator of judicial conduct, and I can prove she lied, I mean that, and when she told me, well, I guess I'm testifying, but is the fact that she investigated, and because she's the only judicial investigator for 21 years, and you reading this stuff should know she lied, was that a concern? Mr. Delifka, of course. I mean, it was, and it was, look at the people that are here today. It was those things that became so troubling, not only in your case, but other cases down there. You would see this stuff and you would just go, my God, that cannot be true. Okay, well, your end of the bargain wasn't met. It was heads I win, tails you lose. You didn't even have to be a lawyer, or you don't even have to be a lawyer to know inherently there's something wrong with that. Mr. Delifka, I'm sure I said that and I still feel that way. That how you, when you went in and told everything you did thinking you had an agreement, turns out you didn't have an agreement and your charge got exponentially increased. That statement I made right there, I absolutely said it. I'm sure, and I agree with it today. Mr. Haig, okay, if you told 1,000 ordinary citizens that for a deal you went in and spilled your guts and then never got the deal, they would find that appalling. That's what smelled so bad to me? Mr. Delifka, I'm sure I said that. I go, the fruit of the poisonous tree started with the warrants, which claimed all the evidence was found where you guide. The dominoes should have all went down right there. That's what I thought Chuck Robinson would latch onto. Mr. Delifka, well, yeah, when I read your case and the lay people here read your case, it appears that the whole foundational thing's built on a lie. Unless we're all misreading it, it looks like the whole deal about section this and all the affidavits, everything had it. And then the hearing, while it wasn't that at all. When I used it, and that was the odd thing to use as fruit of the poisonous tree. We all had that. For us old coots, that was common theory in law school. And once you poison something, it's like a house without a foundation. So all the good folks that are here today that we would talk about, I think almost everyone goes back to that original seminal issue, that how the hell did this case go on when it appears to lay people and to me, a lot of it was built on a lie and a sworn affidavit. Judge Joanides and Mr. Haig, just want to tell you that this kind of information particularly is the kind of information that generally goes to a PCR judge about the legal defects in the case. But again, if you look here, all this has been eliminated for my post-conviction relief by the Alaska Court of Appeals because they said I didn't give specific details. I gave overwhelming details. I asked Mr. Dolifka, everyone in your case had a political price to pay if they did right by you. If they did right by you, the DA would take it out on them and other cases. Then you had the case of your lawyer and the other lawyer got hurt. You had a series of situations which everyone was doing things to protect everyone rather than you because there was a price to pay. Mr. Dolifka, I agree with that. I ask him, your case has shades of Selma in the 60s where judges, sheriffs, and even assigned lawyers were all in cahoots together. Mr. Dolifka, well, I don't remember that, but as a Southerner, I probably said that. I go, okay, everyone's scared to death. The media is scared and afraid. Mr. Dolifka, well, it wasn't this case, but my friend, Mr. Ingleson, that's actually Fred Angleton, and I more than once tried to get our local newspaper to help us deal with our imploding community, and they wouldn't, largely because I don't know if there's a more political area than the Kenai Soldotna. We have fish politics on the river, we're an oil patch, and so we just sit in this cauldron of political things, and those I can live with. When it went into the judicial system is when it became unnerving because fish politics and oil politics is just politics. But when it gets into the court system, which keeps this whole thing together, that was the poison that was disturbing. I asked him, dirty troopers are all interconnected? Mr. Dolifka, we had some trooper problems. I asked him, okay, troopers at least didn't try to kill you like they did one of my other clients? Dolifka, I don't remember saying that, but it doesn't mean I didn't. Mr. Haig, if it comes out I'm helping you, there will be a price to pay. Mr. Dolifka, I have already paid a huge price for helping you, a tremendous price, because I thought what you and I were doing was confidential. I asked him, can you tell me what the price? Mr. Dolifka, no, I'm not going to tell you. I'm not going to tell you anything more because it'll just get worse. In other words, even Mr. Dolifka was threatened and harmed for trying to help me. I asked him, anyway, let me just see if you remember this. The reason why you still not resolved your legal problems is corruption. I can tell you exactly what happened. In the early stages, you were one of the first that I realized it was corruption. At first, I thought it was ineptness. Over time in this journey with you, here's a corrupt case, here's a corrupt case, and here's a corrupt case. Now, here's what happens when they come up on appeal. You have a Supreme Court sitting there looking at a pile of dung, and if they do right by you and reveal, you know you have the attorneys going down, you have the magistrates going down, you have the troopers going down. You're one small part of the pocket. A lot of lawyers would agree with me. The reason is all gummed up at the top. You're just one of many. It's absolute, unadulterated, self-bred corruption. Mr. Dolifka, if it was in that era down there, I probably did say that. It got to such a point of cynicism that I was ready to throw in the towel. How much time have we got?
23 minutes.
Okay. I go on. I asked Mr. Dolifka, I talked to Judge Hanson about this. I talked to Judge Hanson for 3 hours about your case. I lean on him all the time. He now sees it. The system crushes them. I don't have any question now because I couldn't figure out why your appeal could be over and done with. I walked over here and Lawyer A says, my God, they're violating every appeal rule ever. How can it be like this? Mr. Dolifka, well, and I said, I mean, this is, when you said I have absolutely no faith left in the system. During that time, I probably would have said that. There needs to be some new blood in this case, and that's why I'm so happy you got a new judge been assigned to this case. And that was Judge Joanides, and then she got rid of Judge Murphy, and then I got a different judge than Judge Joanides. What this case needed more than anything is an infusion of new blood where there's not old turf wounds. I actually think a new judge assigned to it is the best thing that could have happened because there won't be an agenda that's already been formulated. Okay, and you can go back over there, Cassie. So is it true, as the Court of Appeals claims, that I presented no details of collusion and corruption of my own attorneys, when even a state assistant attorney general testified that I did? Or is it true I presented overwhelming details and evidence to the Court of Appeals, and the Court of Appeals had to lie that I didn't to make sure this evidence that proves collusion and corruption is not presented in open court where my attorneys would be required to refute it? Remember again what the Court of Appeals ruled in here is that I presented no details and evidence of collusion when even an assistant attorney general testified that I did. Anyway, thank you for watching.